in the matter of emotional perception AI against Comptroller, general patents, design citation.
This appeal is about the application in the UK of an important part of European patent law to a claimed invention within the realm of artificial intelligence, centred upon an artificial neural network, which I'll call an ANN for short. Emotional Perception Limited, the appellant and applicant for a patent, claims to have invented a system or method which uses an ANN to replicate the similarities and differences which a human being might subjectively perceive between different files of information by reference entirely to objectively measurable physical properties of those files. The commercial purpose of the invention is to enable a person who likes or is interested in a particular media file, which might be a music track, a video, or a text, to obtain the recommendation of a file calculated to elicit a similar emotional response. Anyone who regularly obtains news items from a mobile phone or watches films on a modern television or uses a music streaming device will appreciate that recommendation services of this type are already widely available. But the applicant says that its invention enables that service to be provided more quickly and accurately and to make better recommendations than anything else currently available. UK patent law is governed by the Patents Act 1977, which aims to bring our patent law as closely as possible into conformity with the European Patent Convention. Articles 52 and following of the Convention set out the 4 essential characteristics of an invention if it is to be patentable. 1, it must be technological. 2, it must be new. 3, it must involve an inventive step. And 4, it must be capable of industrial application. But Article 52.2 of the Convention contains a short list of excluded items which are not to be regarded as inventions at all. They include aesthetic creations, rules for playing games, scientific theories, and programs for computers. If the subject matter of a patent application relates to any of those as such, then it is not to be regarded as an invention and cannot be patented. Section 1 of the UK Patents Act contains provisions to the same effect as Article 52 of the Convention. The question in this appeal is whether the subject matter of the patent application is a program for a computer as such, and how that question is to be addressed. The hearing officer in the UK Intellectual Property Office rejected the application because, in his view, the claims did amount to a program for a computer as such. On appeal, the patent judge, Sir Anthony Mann, disagreed. The Court of Appeal reinstated the hearing officer's decision. The applicant then appealed to this court. The apparently simple question whether a claimed invention amounts to a program for a computer as such has given rise to great difficulty over many years because of different interpretations of Article 52.2 of the Convention, in which it is one of the excluded items. The primary organ for the interpretation of the Convention is the Board of Appeal of the European Patent Office, and in particular the decisions of its enlarged Board of Appeal. National courts, including the courts of the UK, are not strictly bound by the decisions of the EPO Board of Appeal, but they must respect and follow the decisions of the enlarged board unless convinced that they are wrong beyond the ambit of reasonable difference of opinion. For the past 20 years, the courts of England and Wales have followed the interpretation of Article 52.2 of the Convention laid down by the Court of Appeal in 2006 in a case called Aerotel against Telco Holdings. I'll call it Aerotel for short. It was decided at a time when there was no decision of the enlarged board about the interpretation of Article 52.2, and when the decisions of the ordinary boards of appeal appeared to be in conflict with each other. The Court of Appeal laid down a 4-stage structured approach to the question whether a particular claimed invention fell foul of one of the exclusions from patentability in Article 52.2. but it warned that if in future the enlarged board did rule on the same question and came to a different conclusion, then the UK courts might have to reconsider the Aerotel approach. The enlarged board eventually did just that in March 2021 in a decision usually called G119 for short. That decision laid down a quite different approach to the application of the exclusions in Article 52.2 than the Aerotel approach, and it followed and approved earlier decisions of the Board of Appeal which had described the Aerotel approach as incompatible with the true meaning of the Convention and based upon a misunderstanding of the meaning of the word invention in Article 52. Furthermore, the central part of what became the G119 approach had already been considered and rejected in Aerotel. Nonetheless, in the present case, the hearing officer, the patent judge and the Court of Appeal all continued to apply the Aerotel approach with no suggestion from the parties that they should not do so. But the point has been squarely raised in this court: should the Aerotel approach continue to be followed in the UK, or should it now be replaced by the G119 approach? This became the main and, in the event, decisive issue in the appeal. This court has concluded unanimously that the Aerotel approach should now be abandoned and replaced by those parts of the G119 approach which implement the enlarged board's interpretation of Article 52 of the Convention. Lord Leggett and I give the judgment, with which Lords Hamblin, Stevens and Kitchen agree. The reasons why we conclude that the Aerotel approach must now be abandoned may be summarised as follows. 1. The Aerotel approach has been described by the enlarged board in G119 as incompatible with the Convention properly construed, and there is a similarly firm rejection in Aerotel of the main plank of the G119 approach, sometimes labelled any hardware, and which I will shortly describe. The two approaches cannot just be described as different methodologies within an acceptable range. 2. The G119 approach cannot be described as obviously wrong beyond the bounds of reasonable opinion. Therefore, the interpretation of the Convention embedded in it ought to be followed in the UK. 3. The central criticism of Aerotel by the enlarged board, that it involved a misinterpretation of the word invention as used in the Convention, has real force. 4. The Comptroller of Patents' objection, as respondent to this appeal, that the two approaches will always produce the same outcome in any given case, is not capable of proof, and in any event is not a good reason for continuing with a method of applying the Article 52.2 exclusions, which the enlarged board has so emphatically rejected. 5. Contrary to the Controller's case, adopting the G119 approach carefully limited to the part of it which flows from the enlarged board's interpretation of Article 52 will not involve overturning the approach to novelty and inventive step laid down for the UK by this court in a case called Pozzoli. The court has gone as far as it properly can in applying the G119 approach to the facts of this case. It has concluded, in broad agreement with the hearing officer and the Court of Appeal, that the ANN which lies at the heart of the claimed invention is, or includes, a program for a computer. The ANN may be implemented in a hardware or a software form, but in either case it is in essence a program for a computer, the computer being either the single-purpose box of nodes and wires of a hardware ANN or the conventional multi-purpose computer on which a software ANN is run. But the claimed invention is not a program for a computer as such. The G119 interpretation of Article 52.2 teaches that a claimed invention is not a program for a computer as such if it includes any hardware. This is what is called the any hardware approach, to which I've already referred as a main plank in the G119 interpretation of Article 52.2. It is clear that the claimed invention includes hardware, both in the form of what is called the hardware ANN and in the computer on which a software ANN is run. For that reason, the Court concludes that the hearing officer was wrong to reject the application on the ground that the claim fell foul of the computer program as such exclusion in Article 52.2. Accordingly, the appeal is allowed. Nonetheless, the G119 approach contains what the enlarged board describes as an intermediate step before considering the other three conditions for patentability laid down in the Convention. The Court gives guidance as to what that intermediate step involves in a UK context, but it refers back to the hearing officer the application of that guidance to this claimed invention. The intermediate step has its own complexity. It has never been applied before in the UK to this or any other claimed invention. We consider that it would be inappropriate for this Court to undertake it for the first time and without the benefit of the specialist expertise of the UK Intellectual Property Office and the Patent Court.